Good morning. My name is David Hartman. I'm a conservation easement attorney at Smith Robertson Law Firm and a board member of the Texas Land Trust Council for several years now. So I'm just thrilled to be a participant and able to moderate this esteemed panel of experts. We'll talk with the speakers, and we're going to run through the materials and allow plenty of time for Q&A, but I think this is going to be a pretty casual, informative, to the degree you have questions that come up while the speakers are presenting. I'm sure they would be comfortable with you raising your hand or standing up or asking questions, but I hope that we'll have a pretty robust dialogue back and forth at the end. Our first speaker is Aimee Beveridge. She's Project Manager, Site Remediation Section, Railroad Commission of Texas. She's the Brownfields Response Program Manager for the Railroad Commission. She's been the Site Remediation Section of the Commission since '96. She manages the Voluntary Cleanup Program and the Brownfields Response Program. She's overseen the assessment and cleanup of hundreds of former oil and gas sites across Texas under the Operator Cleanup Program. She has a BS from UT and an MS from USC, specializing in geochemistry. Previously, she worked for Shell as a consultant specializing in environmental issues associated with oil and gas, and she told me this morning that she's been a long-standing member of a land trust herself, so she's very familiar with this community. Our second speaker is going to be Burgess Jackson, attorney at law offices of Burgess Jackson. He's an Austin attorney specializing in conservation law, representing nonprofit organizations and public agencies. In 2007, he completed a 20-year tenure in the Natural Resources Division of the AG's office, where he practiced environmental and real estate transactions and litigation. He was a founding board member of the TLTC and has been a speaker at this conference every year since '97. He's a member of LTA's Conservation Defense Advisory Council, and he's authored several publications in the fields of conservation law, including Legal Steps to Starting a Land Trust in Texas. He's a graduate of LSU and the UT School of Law. Our final speaker is David Braun, Principal of Braun and Gresham. David's a land conservation attorney focused on helping clients protect and create value in environmentally sensitive land. His firm, Braun and Gresham, uses conservation easements, conservation development, mitigation banks, and other similar approaches in real estate, tax, and regulatory law to bring incentives to clients who wish to protect their land. Dave is also co-founder, chairman, and CEO of Plateau Land and Wildlife. It's a group of biologists and property tax consultants dedicated to helping landowners and developers protect and enhance their rural open space land. He served as director of the TNC for 8 years in the '90s. In the environmental arena, known for its clashes between polarized factions, he's built a reputation as a skilled consensus and coalition builder. He's a certified senior property tax consultant and manages Plateau's property tax practice. Please welcome our panel.
I didn't bring any slides or anything. Can everybody hear me okay? No? All right, thanks for speaking up. I'll do the same. In fact, I might even take this mic. All right. Well, I am here on behalf of the Brownfields program. If you've had a chance to go by and see our booth, one of the things that the Railroad Commission has to offer is free environmental site assessments to land trusts, municipalities, nonprofits, churches, schools across the state of Texas. This is a grant that we received from the EPA, and it's to assist with redevelopment of properties so that pristine environments can be maintained and that we reuse the sites that already have infrastructure on them. Like, for instance, if you think of the gas station on the corner, well, that already has utilities, it's got sewer, it's got pipeline, it's got all those things. Why would we want to move that another type of use out to the cornfield? You know, that's just the basic idea of what brownfields is. Let's reuse the property that we've already got and not cause sprawl. So in that, the Railroad Commission is the first energy conservation agency in the country to also receive one of these grants. And as you know, Texas has a long legacy of oil and gas production. And because of that, we have abandoned oil and gas production areas, and these are perfect for redevelopment. The contaminants that might be present need to be evaluated. So the message that I want to leave, especially for our land trusts are in a position where you're responsible for properties that might be brought to you. Maybe they're donated. Somebody wants to give you some land. That the message is, make sure that you do a phase 1 environmental site assessment at the time of the property transfer, before you buy it. Why is this important? Well, it protects you from environmental liability as a bona fide prospective purchaser, and this can be done with our brownfields funds. So you can fill out an application, and we can do these environmental site assessments for free. And I'd like to say that we're very quick and responsive on that. Sometimes I know how it is in real estate. Things need to happen tomorrow, and we try to be responsive, and I think we do a pretty good job of it. Some of the projects that I've been involved in, and I'm very proud of, one of them in particular is in Chambers County. I'm working with Galveston Bay Foundation and the Chambers Liberty Navigation District. And there's a 500-acre tract that's going to be set aside for nature preserve. It'll probably have limited visitation, but it's got a tremendous amount of wetlands and uplands, and it's in pretty good state of preservation because it was an oil field. Now, I know that's kind of hard to imagine, but when you look at where the open spaces are, in the Houston area, for instance, if you took a Google map and you started looking, why isn't that developed? Why is that large portion open? Well, in many cases, it's because it was an oil field. So I guess I want to challenge you to think that in some respects, these are perfect opportunities for us to set aside for green space. They are already used by a lot as habitat for wildlife, and they are perfect. And they have, I will also argue that for an industrial use property, the contamination is very, very low compared to, say, any other industrial use, refineries or chemical plants and so on. So just want to throw that out there, that these are opportunities for preserving green space, and especially in areas where, like Houston, where there's really a lack of there's a lot of private land and there's not a lot of public land available for that, and yet there's a real richness in the diversity of wildlife. So I want to throw that out there, as these are kind of just to get an idea that sometimes oil fields can be, there's a lot of people think they're just bad, but they really do have a bright side. So I know that the title of this is Emerging Issues, so I think I owe you some news. And one of the things I wanted to mention is that the Railroad Commission is, people talk a lot about fracking. We're very concerned about this because we're going to see a tremendous number of wells. There's no doubt about it. I don't know how many of you attended the session on oil and gas yesterday, but Joseph Fitzsimmons very, very plainly said that the projection is that we're going to have a tremendous increase in the amount of oil and gas wells. This is something we're going to have to live with. The people are concerned about fracking fluids and what's contained in fracking fluids. The Railroad Commission initiated a rule already that declared that you have to state what the fluids are composed of, and those are reported on a website called by Frac Focus. And I just looked at the Frac Focus website, and it's nationwide, voluntary reporting in a lot of other states. But of course in Texas it's not voluntary, it's required. Over 37,000 wells have been reported to the Frac Focus website. So I think that that's progress. I think that's really good. I think people have a right to know what's in frac fluid. Another thing that Joseph mentioned yesterday, and I think this is really important, is that frac well is a well that starts out as a vertical hole, and then it deviates and into the shale. And it's a tremendous technology that these engineers and scientists have been able to design a wellbore that has so much control that they know within feet where that wellbore is. It's extraordinary. But I also want to mention that there's a concern about frac fluids escaping the zone of interest and getting into drinking water wells and drinking water zones. The likelihood is very, very low, and the reason is that these zones are at 6,000 feet. They're well below the drinking water zones. So, but Joseph also mentioned another thing, and that is that every well starts out as a vertical hole. Well, it's true that if you're going to have contamination, it will be at the surface, where those pits that might have been, whether the well was plugged and abandoned properly, and the environmental regulation and quality of wells has improved a lot. So new frac wells are going to be the highest standards of the day, whereas the old abandoned wells, those are the ones that are, I think, really the most concerned, and the Railroad Commission is very concerned about them. We have a fund called the Oilfield Cleanup Fund, $20 million fund, that it's funded through the production of oil and gas. So every barrel of oil and every MCF of gas in the state of Texas, a portion of that gets contributed to this $20 million fund. So with that money, we plug and abandon thousands of wells every year, and we also we do a lot of cleanups, environmental cleanups of abandoned facilities. I want to mention that because you may have property that might have abandoned facilities on it. Please let us know. We've got a candidate list we maintain, and because we're efficient at cleaning these things up, we're starting to reduce the number of sites on our candidate list. Bring them to us. Let us know where they are. It may look like what we call an old tank battery. It may look like an old pit with a liner. You may not know what it is, but if you bring it to our attention, it's something that we could look at and evaluate and possibly clean up if the risk. Of course, we always evaluate things in terms of human health. So if the human health risk is there, then yes, we're going to clean it up because that's the responsibility that the Railroad Commission has. So. Let's see. Railroad Commission doesn't regulate certain things, and I'm going to go ahead and go through this now. We don't regulate noise. We don't regulate lease agreements. We don't regulate the odors and vapors and air pollution. That's all by TCEQ. That's their purview. Let's see. We do regulate the pipelines, natural gas, oil and gas production, exploration, the permitting of surface mines. So lignite mines in East Texas are regulated by the Railroad Commission. The exploration of uranium, although not the permitting of uranium. So don't ask me why, but I think that pretty much covers what we do. Absolutely nothing with railroads. Thank you for asking that. I love that question because it happens so often. And no, we don't. In 2005, our jurisdiction over railroads terminated. And the Railroad Commission is the oldest agency in the state. A lot of people don't know that. But yeah, that was originally what we were designed to do. And so no, and the good news is there's been Sunset Commission has made a recommendation that we change our name. And I think there's been definitely been one bill so far for the name change. But the hope is that, and I really I'm going to retire someday, and I'd love to be able to retire not from the Railroad Commission personally. I'd like to retire from the agency that what we do, which is the Texas Energy Resource Commission. It may be that, it may be the Texas Energy Commission, it may be the Texas Oil and Gas Commission. I don't know, they don't know what it is. But that's what I hope it'll be, and I'm kind of excited about that. I'm not familiar with any other bills in this legislative session that are going to directly affect people. There is one on forced pooling. That is a topic that's very contentious to some people. Forced pooling is, I have a piece of property here, you want to put a well in here, and I'm not going to allow you to have a lease, but you want to drain minerals over here. Okay, so forced pooling would require that I would give you permission to put your well bore in horizontally and then drain this pool over here. Wow, that's a big deal. And so I don't know what the status of that is, but there is limited pooling, and there's some consideration that we should change the laws to allow that to happen. So those are interesting topics. They create a lot of problems and issues for people. I don't know. Let me see. I think that about covers everything I was going to talk about. Does anybody want to ask any questions, or shall we just go to the next speaker? All right.
Thanks, Aimee. All that excellent presentation, all that information was definitely new to me, and so certainly constitutes emerging issues. As our next speaker gets here, 2 housekeeping items. Burgess's presentation, copies of his presentation are back on the back table. And any attorneys who are looking for continuing legal education credits needs to sign both the sign-in sheet at the back table and also the sign-in sheet at the registration desk. Here's Burgess Jackson.
Thanks, David. The handout is titled Emerging Issues at the top. The Texas Land Trust Council asked me to give a presentation on issues that have come up for land trusts over the last year. So this is going to be kind of a random walk through some emerging issues. And I'm going to have to fast forward through some slides. They gave us no transition time between the end of the last session and the start of this one, so we got started 20 minutes late. So one thing I'm going to fast forward through is some of the presentation about mitigation banks. One thing I've observed since the expiration of the enhanced federal income tax incentives at the end of 2009 was I've been observing fewer donated conservation easements, and at the same time more what I call commercial easements, which include mitigation banks. And I was going to give kind of a 101 mitigation bank, but given how late we're starting, I'm going to fast forward through that. If anyone wants to read these bullet points on the handout, they'll kind of coach you through how a mitigation bank or conservation bank, same thing, actually works. But the thing that land trusts are engaged in is land trusts hold the conservation easement. And the conservation easement is what allows the federal agency to issue credits to the banker, which they then sell at market value. So this is not a donated conservation easement. It's one where the instigator of the easement is involved in a commercial transaction. In addition to mitigation conservation banks, there are a number of conservation easement purchase programs. The Federal Farm and Ranch Land Program is one. In that case, a landowner receives from 75 to 100% of the value, appraised value of a conservation easement in cash. In addition, local governments, this is something, if you've been at the conference, you've heard a lot about. Travis and Hayes County, City of San Antonio, and Austin have conservation easement purchase programs where they pay 50 to 100% of the value of the easement. Now what this means is that banks and purchase programs provide more money to the owner than a donated easement is. So you may have landowners who are less conservation minded than those who are merely donating a conservation easement. And in some cases, with the mitigation banks, they're not interested at all in conservation. Some of them are. It's strictly a commercial transaction. And the question is, should land trusts treat these commercial easements any differently from donated easements? And the bottom line is always to protect the conservation values. And a few specific issues I want to go over. One is mineral development. In a donated conservation easement, there are IRS regulations that the landowner has to comply with to get the deduction. One of these is surface mining can't take place on the property. Problem is that most ranches in Texas have a small pit where they excavate soil to use for road base on the property. This can be problematic in a donated easement, and we kind of soft shoe around it, and even that is not a certainty the deduction will be allowed. In a non-donated easement, you don't have to worry about that. The landowner can have a quarter acre, half acre, 1 acre, whatever is appropriate pit to mine road base for use on the property. Another issue with minerals and donated easements is one way landowners can get to the deduction is to receive a letter from a geologist that says the chance of recoverable minerals on the property is so remote as to be negligible. By minerals, I mean oil and gas. And in a commercial easement, that's not necessary. The land trust still needs to be sure that if mineral development does take place on the property, that it's not going to overly impact the conservation values, but there's no need for anyone to go out and hire the geologist and produce the remoteness letter. The other item I want to talk about is title investigation. 5 years ago, for most land trusts, title investigation meant the landowner gave them a copy of their deed and assured the land trust that they own the minerals. Enter accreditation from the Land Trust Alliance, and that has significantly upped the bar on title investigation for conservation transactions. Practice 9H of Land Trust Standards and Practice is the land trust investigates title for each property which it intends to acquire title or a conservation easement. What does that mean? To investigate title, the land trust should obtain a title report or abstract. What's that? A title report is a document indicating the current state of title, including the name of the owner, easements, liens, other encumbrances, usually prepared by a title insurance company. Now, with title insurance, the title company will guarantee the state of title. A title insurance policy is a title report that's guaranteed by the title company. There's no guarantee with a title report. And here's what I want land trusts to know about title investigation. Title insurance companies, rather, are in the business of selling title insurance policies. They don't like to sell title reports, and my experience is they don't do a real good job on them. They have no skin in the game. Whereas if they're guaranteeing title, that is, if there's an encumbrance or the title transfer fails, then they have to pay money. So I've observed that they do a much better job when there's a title insurance policy involved. Now, title insurance can be expensive, and on large properties that are valuable, title insurance can run in the thousands, even tens of thousands of dollars. And in a donated easement, where the landowner is already paying other expenses and they're not getting any cash in return, that can be burdensome. So what I have come up with over the last year, and this seems to be working pretty well so far, is that we will stipulate that the value of the property is $100,000. And we ask the title insurance company to give us an insurance policy for $100,000 rather than, say, $1.5 million, which could be the value of the easement. And title insurance companies are used to doing this because in rural areas they do policies on single-family homes for $100,000. And it's going to cost about 3 times more than a title report to get a policy valued at $100,000, but it's really worth it and usually still comes in under $1,000. in a commercial, non-charitable conservation transaction, it's my thought that the landowner or the banker, as the case may be, should provide the land trust with a title insurance policy for the full value of the conservation easement. Why is that? In any other commercial transaction, that's what the parties would do. If the seller were merely selling the property to someone, the buyer would insist on having a title insurance policy for the value of the interest. Third item is enforcement costs. We usually put a clause, we land trusts usually put a clause in conservation easements that if the land trust has to enforce the easement and wins, that it gets its attorney's fees, its costs reimbursed. Most landowners say, well, you may wind up suing my kids. I don't want you to reimburse you to do that. Well, in a commercial transaction such as a bank, the risk-reward balance, in my mind, is such that there's a substantial reward on the side of the banker, and that they should be paying the land trust enforcement costs if the land trust does its job and prevails in an enforcement case. The next emerging issue is mineral rights. And I was going to read you a couple of paragraphs from a workshop that I took at Raleigh on mineral rights, and I'll paraphrase it for you, that basically a very, very respected and knowledgeable commentator in the land conservation field said that when severed mineral rights are involved, that is, a different party owns the minerals than owns the surface of the land, you need to hire a knowledgeable a knowledgeable oil and gas attorney in your state, a biologist, a petroleum engineer, and a production engineer at a minimum. I'm sure all of you have done that in all of your conservation easement transactions. Will anyone admit to not doing even one transaction that way? Oh, I know. I'm so proud of y'all. Good. Okay, you were the first one to laugh, so I'm going to give you a chocolate bar. That wasn't intended to be a joke. Okay, this little spiel on mineral rights pertains to donated conservation easements as well as non-donated. And had I known that the two speakers yesterday, Joseph Fitzsimmons and Kathy Howell, were going to do such an excellent job on their mineral rights presentation, I might have picked another one. But what I have observed in previous seminars on mineral rights at conservation seminars is they tell you about the law, but what the land trusts want to know is, what do we do? It's a difficult situation, and there are no great answers, and I will try to summarize them quickly. And here's a real caveat in bold. No one knows for sure what to do with mineral rights and conservation easements. The best experts will acknowledge this, and what I've done is just basically collate the opinions of the top experts on this. The place to start is to find out who owns the minerals. You want to find out if the owner of the surface of the land is the same person who owns the minerals, or if a third party owns it. Starting place is ask the landowner for a copy of their title insurance policy that they got when they obtained the property. If it's a legacy property that's been in the family for generations, they may not have one, and in that case, they should get a new one for you, which I think should be done anyway. And I would actually want to delete where it says obtain a current title insurance policy. I would want to delete or title report. And then someone who understands land title should review these policies. And if who owns the minerals is still unclear and there's a lot of money involved, the landowner may want to hire what we used to call a landman. A lot of title investigation now is done by women. and research the title, and they may need to go back to the 19th century to find out who actually owns the minerals. But with a big deduction involved, it might be worth it. So we've done our title search, and we find out the landowner owns the minerals. This is the best situation we can have because they have control. And the first choice is a conservation easement that bars surface use, bars the use of the surface of the property for mineral development. Now, in my opinion, it would be acceptable to allow the owner to pool their mineral interest with other persons where the landowner gets to have their cake and eat it too. They get paid for their mineral interest, but the mineral development takes place on somebody else's property. There are other folks who disagree with this and think that land trust enabling any oil and gas development is wrong, but I'm giving this presentation and they're not, and I think pooling is appropriate. So if the surface use is used for mineral production, you want to include language from the IRS in the conservation, from the IRS regs in the easement. No extraction by any surface mining method, limited and localized impact, no significant impairment of conservation values. And most importantly, include the right of the land trust to participate in any consent by the landowner, such as a lease or in any surface use agreement. What if you do the mineral search and find out they've been severed? This is way more problematic. A few options the landowner has. One is to approach the mineral interest owner and obtain a surface use agreement from them. And let me digress a moment here and say that to really do this well, you'll get a much better surface use agreement if it's negotiated by someone who is an expert in this. I know of land trusts who have engaged Joseph Fitzsimmons' oil and gas law firm in San Antonio to negotiate leases for them, and they've done an excellent job, including on the surface use agreement. The other option is just buy out the mineral interest owner. And the problem is that, both of these options do cost money. And the last option is that the landowner can obtain the report from the geologist saying that the probability of extraction of minerals, and the letter should say both surface and subsurface minerals, is so remote as to be negligible. And even if you obtain the mineral remoteness letter, there are very qualified experts who think that even with the remoteness letter, a deduction is not guaranteed without a surface use agreement. On the handout, there are links to a couple of excellent resources on minerals. One is the Colorado Coalition of Land Trust Mineral Development Handbook. It contains a model surface use agreement which would have to be adapted to Texas. Again, it's better to have an expert negotiate the surface use agreement for you. And the other is the Bureau of Land Management Gold Book, which is the standards for oil and gas production on federal lands. A lot of mineral producers are familiar with the Gold Book. They've used it before and may not completely freak out when presented with it. David, you were the first to laugh. I'm going to give you a chocolate bar.
He gives high content chocolate bars, like 85%.
These are endangered species chocolate bars. You get the wolf.
The wolf.
The predator.
All right. The green light in the eyes.
The green fire, yeah.
Green fire.
This is pretty heady stuff. I just wanted to take a minute, let y'all look at a pretty picture, and let me check my time here. We're doing okay.
Mr.
Yeah.
insure mineral rights title?
Yes. That is if they are confident of what the mineral rights are. In a lot of cases, the severance of mineral rights, where the mineral rights were conveyed to someone other than the owner of the surface, took place so far back that there's not an existing title policy that shows a record of that severance. And in that case, they usually won't. They now have a blanket exception that they can put in that accepts their coverage of any minerals, coal, gravel, the whole oil and gas, everything. And if they don't have a record of that, then they won't insure the minerals unless somebody's willing to pay them to go way back in the dark dungeon of the title plant and, you know, go back to 18, you know, whenever it was that the severance took place. So. But I have seen them insure it when they are confident of the mineral ownership. Easement amendments, conservation easements. George.
Burgess, I'm confused about caliche pits. So a farm and rangeland protection purchase easement does have a charitable deduction component. So would you say again in that instance, what language needs to be in the easement about surface mining of the caliche?
We've done several things about that. One is to look proactively to the future. We think there's an incorrect court opinion that concluded that a small quarter-acre caliche pit would destroy the conservation easement on an 1,800-acre property, for example. We think eventually that will be overturned or the law will be changed, and so we've written it so that essentially that no caliche pits can be mined until it is permitted under existing law, regulation, court decisions, blah, 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 looking proactively. Another way is to carve it out of the conservation easement, just take an acre in the middle of the property and, you know, or wherever the pit is, and just leave it out of the easement. Another way is to just really dress it up and say that cannot impair conservation values, cannot be anywhere near the sensitive features, must be restored, cannot ever be larger than 1/4 of an acre at a time, and so on. And then other people have been completely silent about it. They've wanted to be silent about it in the conservation easement, just says no surface mining. And then on the baseline report, there's the old caliche pit. It's marked, you know, so that it's an old, pre-existing feature on the property, and you know, they figure they can go in and scoop a few truckloads out each year. The Land Trust is probably not even going to mark it on the annual monitoring report because it won't even be noticeable. And they just think they can, if they just stay silent, that it will never be raised as an issue. So that's a long answer to your question.
That's very helpful. Thank you. One more quick question. I hope it's a quick question.
Let me get comfortable if you've got a quick question for me, George. Got a chair?
I thought I heard you say that it was permissible to tell the title company that the value of the donated easement was $100,000 and buy a policy for $100,000. What relationship, if any, does that $100,000 number have to the number that will appear on the 8283?
None. None whatsoever. The value is shown on the appraisal summary. Do you agree with that, David and Allison? Is what's going to be on the 8283. What the title company has is of no significance to the market value of the property. That's the policy amount. Pardon?
If they had missed something, that's their skin in the game, as opposed to the fair market value of the easement. That's what the title policy's exposure is.
The title policy's exposure is the amount of the policy. Correct. Yes, exactly. Okay. I don't want to cut too much into David's time here. Conservation easement amendments. This is another increasing area of scrutiny by our friends at the IRS. Land trusts on their annual Form 990 tax return, Schedule D, have to indicate how many easements they've amended. And the reason for this is easements are intended to be perpetual, but they can be, under the law, be amended. And because conservation easements have public implications, changes to them have public implications. And there are certain types of amendments that commentators feel should not be done by the private parties, by the landowner and the land trust, but require some level of public review. And public review means review by the Attorney General or a court or both. And there's an ongoing, very spirited debate nationwide over what is appropriate public review. Oh gosh, don't anybody leave the room when this next slide comes up. Okay, let me try to explain what's going on here. A land trust years back did an old easement that they regret now. And they took a subdivision that had 70 platted lots. The lots were 8 to 10 acres each. The little yellowish cream color area in each one of these was a building envelope, and the green area surrounding was an allegedly protected area. And it didn't take the land trust long to figure out that this was a completely dysfunctional layout. That once this subdivision was built out, they would be dealing with 70 different landowners with 8 to 10 acre plots. And that when it comes to paying your conservation defense insurance premium, that's 70 premiums per year. And it had very little conservation value because of the fragmentation. Well, not many lots were sold. The development was foreclosed on. And the bank, when they tried to sell it, couldn't sell it. They couldn't get title insurance because the dividing line between the building envelope and the protected area was so poorly delineated, no title company would insure it. So they were stuck, the land trust was stuck. They negotiated an amendment. The hickey was that there were some sold lots that were interspersed with unsold lots. And the unsold, let me back up. The big picture amendment is going to be that there were going to be, say, 3 large lots with building envelopes in them, which would have some conservation value that the bank could sell. But there were some interspersed lots in the lots owned by the bank that were interspersed with lots that had already been sold. And we knew that we could not get all of the owners of the sold lots to participate in an amendment. So what we had to come up with was to remove the conservation easement in its entirety on the unsold lots that were interspersed and fragmented with the sold lots. And the protected areas on those lots that were being extinguished, the protected area would be moved over into the large contiguous lots so that we got some real conservation out of this. However, because certain lots were being taken out of the conservation easement altogether, we felt that we could not do this with just the private parties. We consulted a national expert on amending conservation easements, and we came up with a plan to extinguish a portion of the easement, and we would have the large contiguous lots that would have some real conservation value, but we were preparing a packet to send to the Texas Attorney General for their approval. There's recently been a court case come out called the Belk case about trading land in and out of conservation easements that's going to cause us to sit down and reconsider whether or not we have to go to a court. But at this point, we're not planning to, because of the really the original purpose of the original conservation easement was defeated. No real conservation was taking place, and it is going to take place with the amendment. Last part about amendment is a similar area in this subdivision had the same configuration, but there were no sold lots in there. So the bank that owned this area had complete control over the property. And the bank and the land trust negotiated an amendment that again had a few large lots with building envelopes. And some of the conserved area in the original configuration may wind up being in a building envelope in the amended area. However, it's still going to be within the framework of the conservation easement, such that all activities on the property must conform with the purpose of the conservation easement. So it's still protected. It's basically like moving around, moving the location of a building envelope. When you're moving a building envelope, the area that's no longer going to be the building envelope is still protected by the conservation easement, and there is good authority, or not authority so much as pretty solid expert opinion that an amendment to relocate a building envelope does not require public approval, that the parties can do that themselves. So to sum up, we felt that a conservation easement that took any property currently under easement out of easement needed public approval, and a conservation easement merely to essentially relocate a building envelope where no property was being taken out of easement could be done by the private parties. This is still a developing field, but that's where we are right now. Last thing I've got. Does anyone know the date that the terra firma Conservation Defense Insurance Program becomes effective covering land trusts? Who said March 1st? Catherine, you've got a chocolate bar. I'll give it to you after the class. Well, someone actually paid attention and read the handout. Good. Okay, you get a chocolate bar. This is a major step in land conservation that conservation defense insurance coverage starts today, and that is for violations that occur after 12:01 a.m. March 1st. If you've been negotiating with a landowner for a year and a half and you just don't see eye to eye and it's not going to work out, that's a pre-existing condition and is not covered by the policy. But any new violations after today are covered by the policy. But my message for you is, with the land trust conservation easement violation policies, it's going to have steps in there of your communications between the staff and the board, inside the board, and so on. You need to amend the policies to add communication with the terra firma defense insurance company. What that means is, as soon as you see there's not a meeting of the minds between you and the landowner, go to the website, terrafirma.com, call Leslie Ratley Beach, who many of you know, tell her the situation, or her assistant, Laurie Barrett, or send them an email on the website, and that's how it works.
20 minutes left. About 20 minutes.
Yeah, well, David needs his time. Yeah, okay. Let me turn it over to David, and another pretty picture. And if there are any questions, oh yeah, take the promo slide off. You have a Braun and Gresham promo slide? We'll put that. I'm surprised you don't have one.
Okay, well, this is a very serious-looking group. I should have known I was in trouble when you guys signed up for this group over 2 funding opportunity sessions that are head-to-head with us. And I'm going to make it worse. Lori asked me to talk about the Butler case, which involves litigation over Section 1.170A-14E2. So you guys want to talk about that, right? Actually, I've got a solution, because Lori said, well, Butler case and anything else that is on your mind. So I'm going to take a second and tell you about electric cars. I'm researching electric cars right now, and everybody should be excited about them. 2013, I predict, is the year that the tide has turned. All the industry is producing interesting cars, and the city of Austin, at least, has installed hundreds of charging stations. It's really doable now. You can give up your Prius and move into a plug-in hybrid or a pure electric car, and it works. And I'll just tell you about 2 things. Tesla, who's known for making sports cars, is now making what they call Model S, a sedan. It has a 300-mile range on one charge, and it can charge in 30 minutes. And so buy one of those. They're only $85,000. Or if you want something just a little more down market, Ford has come out with a great line of cars that they call C-Max, and they come in all kinds of configurations. The one that's, I'm confused though, because I think the C is for carbon, and they're all about less carbon, so why don't they call it the C-Min, right? It's C-Max's marketing talk, I guess. But the plug-in hybrid that they're making, it's a roomy, comfortable car, and you can do all of your commuting on electric only. And then if you got a long road trip, it switches over to hybrid. So that's on my mind. I thought I would share it with you. Now we have to talk about the Butler case. So I gave this presentation at the Advanced Topics Workshop in Charleston, and I'm going to admit to you this is purely me speculating. There is no right answer here, but early in 2012, the tax court decided the Butler case, and I think it teaches us some major things about dealing with the IRS, winning audits, and how to use your baseline as a defense for audits. And so I welcome anyone, including lawyers from my firm, who want to disagree with me. This is my suggestions and what I'm suggesting to clients. So here's what happened in the Butler case. It's a very complex case. The opinion is 185 pages, single-spaced, and so you wade through it. And here's the interesting part. There was many tracks going under different kinds of easements, but one 418-acre tract reserved the right to have 11 two-acre building envelopes on it. So, you know, in my opinion, not a good easement anyway. It's a lot of reserve rights. But the Butlers were longtime members of the conservation community, and they had gone to a lot of trouble to do this easement and thousands of other acres of easements, and they decided to fight it. And so they went all the way to court and had a trial, and they won. And the reason that the tax court judge gave was that when he looked at the baseline, the experts who wrote the baseline had a few sentences, just a few sentences saying, well, given what we're trying to conserve here on this 418-acre tract, we believe, in our expert opinion, that these 2-acre building envelopes will not impair the conservation values. And the judge said, well, IRS didn't bring an expert, and this expert said that it's not going to impair the conservation values, so I'm going with the expert. Now, I don't recommend this to defend bad easements or to stretch the limits of credibility, but I think the message that is really interesting is that the expert opinion swayed the judge. Now, probably next time, the IRS is going to hire an expert and bring their own opinion. But I think that what turned on a light bulb for me was that baseline report was, in fact, an expert witness report. And for those of you who've had any involvement with litigation, you know that your expert studies the situation, prepares a report, and defends it, basically, on the stand. That's what happened here. And so for very important, large easements where big deductions are involved, I'm advising clients that it's worth going to the trouble to prepare an extra special baseline. And here's what I mean by that. Instead of just documenting what is there now, I think that a conservation expert, we'll talk about what that is, should also use the baseline to analyze how the terms of the baseline are effective in accomplishing the conservation purposes and whether or not the reserved rights are impairing the conservation purposes. And so there's really three things involved. What are the conservation purposes that are listed and important in the easement? How are the terms of the easement protecting those? And how do the reserve rights impair them? It's all interwoven. Your baseline needs to comment and address those from an objective scientific point of view. And what it does is begins to concentrate everyone's mind on whether this easement's defensible and how you're going to defend it if the IRS attacks it. So let me stop right there and see if there are any questions or any questioners or doubts, and anything you want me to elaborate on.
Was the baseline just admitted as a business document, or did preparer come to court?
That's an excellent point, and it did turn on state law issues. So for those of you, again, who are lawyers and thinking about litigation, it's if you don't record the baseline as part of your easement, then it may not be admissible in court. But in this case, it was not recorded. It was referenced in the easement, and according to the Georgia business documents law, it was admissible. But so that is a good reason to to record your baseline, depending on the state you're in.
What's Texas law on that?
Yeah, I have researched that, and incorporation by reference is an effective way to get it into evidence in Texas.
Good, thank you. Other questions?
Isn't the intent to demonstrate that the reserve land uses do not affect the conservation?
Well, that's what you'd want your expert to tell you, but of course, this is an interactive process, and if the expert comes back and tells you, oh, well, I'm not going to sign my name that these reserve rights do not impair, then you might have to think about the reserve rights and how expansive they are. But yes,
In the event that you were willing to accept an easement, recognizing that the reserve rights may impair the conservation values, however small, you're still providing an opening to terminate the easement somewhere down the road.
not terminate, but the donor might lose their deduction. And so
Well, I
you,
mean, cutting tax issues aside, if the reserve rights are demonstrated to a maximum extent, to where there is, the conservation uses can no longer be maintained or realized, then you have grounds for termination of the easement.
well, yes, and I would not hope none of you are accepting such an easement, but this is in the more gray area. This is in the gray area where you think, well, 11 2-acre building envelopes in 400 acres, that's 22 out of 400 acres. This land trust thought, well, we'll take that. There's enough important habitat here. We'll take that and let 22 acres be lost. That's in this gray area. Do those 22 acres impair the remaining 400? And the IRS said yes. This whole easement fails the charitable gift test, and all the work you're doing on the 400 acres is not deductible. And it does focus the mind of the person preparing the baseline to sign their name and their expert opinion that there is no impairment. And that's very helpful to get everybody who's involved in drafting this to really think through those issues with clarity, point by point. As a lot of you know, I own a company that's wildlife consultants, and we prepare baselines. And what we've told our people to do, if the client is willing to pay for it, is to point by point go through the conservation purposes and have an analysis of how this easement's restrictions protect that conservation value, and then point by point each of the reserved rights, whether or not it impairs the conservation values. And if so, how much? Because how much is a big problem. All of this is based on, remember what I said, section 1.170A-14E2 of the Treasury regs. And what that regulation says is that no conservation easement will qualify for deductions if it allows the impairment of significant conservation interests. And it gives one example. The example it gives is you cannot preserve farmland and allow pesticides that are harmful to the larger ecosystem in which your farmland occurs. So that's all the guidance we have. A lot of people quote that regulation and say you cannot materially impair or you cannot significantly impair. But that's not actually what it says. It says no impairment of significant conservation values. I don't think IRS meant that. The no impairment standard would, in my opinion, mean you have no reserve rights at all. And their example would lead you to believe they don't really mean it, because they say of a pesticide that significantly harms the ecosystem. So we know unless you're going to require all organic farming, then no farmland conservation would be possible, because all pesticides have some impact on the ecosystem. And so there's this gray area. We've got to, all legal issues have it. We've got to try to figure out how much impairment and address it. So some people who disagree with me say, better just to remain silent, just hope the IRS doesn't audit you. But what I see as a trend is IRS is trying very hard to establish law, new law, and they are challenging, in many cases, what are perfectly good easements, and trying to draw some lines on what's permissible and what's not. And so it just makes sense to begin preparing your arguments and your position scientifically before you get to that position. So would I do this? I mean, it adds some time and money to a baseline. Would I do that for every small easement that you write? Probably not. But on bigger projects where millions of dollars are at issue, a few thousand more for a baseline is worth it, I think. I guess another issue I should mention is there are, in my experience, more and more land trusts are offering to do baselines as part of the service that they provide. And that's been much welcomed in the industry. The landowners appreciate that. But it's not required. If you look at the baseline regulations, it's the obligation of the donor to provide the baseline. And the donor really has a specific duty to deliver a baseline to the land trust on which they both agree. So if you want to shift this responsibility back to the donor, there's actually some value in that, because if the donor hires a third-party independent baseline preparer, that witness is going to have a little more credibility than the parties that are involved in the transaction. There's always an issue of, especially in the bad actor case, that the land trust wrote the baseline in a self-serving way, and that their position is not valid. So having an independent person, of course you can hire a corrupt scientist too, there's plenty of that goes on, but it's a little more credibility to have a third party do it. Yes, Vanessa?
Have you found, since you said you started doing this, that it gives the landowner, I guess the land trust also, more assurance or clarity, apart from IRS scrutiny, that the reserved rights long-term aren't really going to impact any of the values? Seems like there's a benefit there, perhaps.
I think so. I can't say that I've actually experienced that yet, because it's too new and I don't have enough experience. But to me, I think it raises the level of the discussion and brings in a scientific rigor that hasn't been there in the past. And so I think it has very much has that value.
And then I have one more question. Have you found that the experts on the ground are actually able to make that determination? And I wonder if that's difficult.
What I have found is different scientists react differently to that request. Some of them are like, oh my God, I have to give an opinion and I might have to defend it. I just document things. And then there's other scientists who say, yeah, I do that all the time. And so, I mean, I see Cliff nodding his head down here. You're asked to give opinions all the time. That's what a professional biologist does. So the biologists that work for you may not have been asked to be expert witnesses before, but the professionals have usually. Yes?
If I have two questions. One is on the size of the property in this case. If I understood you right, the 418 acre tract was just part of a bigger assemblage of tracts, a bigger range or something, and it was that one that had the building in it.
Exactly.
Well, that kind of tells me a lot, and to me, it doesn't seem like, on its face, it doesn't seem like that 20 or 11 of the building sites would be necessarily that.
Yeah, it's an interesting question. I think that's the way the donor and the land trust thought about it. There were 5 tracts totaling more than 1,000 acres, and all the building envelopes were concentrated on this one. But the IRS and the judge treated each one separately because they were separate easements, and they challenged the integrity of this one.
And was the baseline report prepared by the land trust or the landowner?
They had a independent consultant, and I don't know if that would have made a difference. I mean, this judge, it was clear, and we are seeing with a lot of appeals that get to a judge, that I'd say the trend is for the judges to go with the landowners and overturn the IRS. So, hold on to your pocketbook and fight on. But it was clear the judge was looking for anything. And it was literally 2 sentences that I think the consultant just sort of tossed off. It was never thought about as an advance of what value it was going to have. But the judge zeroed in on those 2 sentences and said, I'm deciding the whole case on that.
If you had a situation where your questionable reserve rights were in one part of the tract, would you ever consider dividing the transaction into 2 and doing an easement on the pristine portion and a separate easement on the reserve portion?
Wow, I've never thought about that, but may I borrow that idea? Yeah. I think that is, look, maybe I'm hypersensitive because, I've dealt with a dozen IRS challenges, won them all, in the last few years. And so I'm really sensitive to the IRS being aggressive and unreasonable, at least at the examiner level. And so, yeah, if I really wanted to isolate or limit my liability, I can push my worst case over into one basket and fight over that, but the rest of the deduction is safe. Are we out of time?
Unfortunately, that's our time. I'm sure our experts would be willing to hang around and answer any questions. Please join me in thanking them for their expertise.